Good afternoon and a warm welcome to today's edition of Democracy and the Rule of Law, a program where we'll take a look at topical national issues from the perspective of the rule of law and the Constitution. My name is Judith Urenwa. Today we have the details of the Supreme Court judgment which handed victory to the candidate of the All Progressives Congress, Senator Hope Uzodinma. All right, following this particular judgment, you recall that different criticisms, accolades showed it. The People's Democratic Party in different states trooped to the street protesting this particular judgment, calling for its reversal. Would you say, with the details of this judgment, things will be different and people will look at this particular judgment differently? We have the details, and this is what our legal practitioners will be looking at. From that perspective is what they'll be analyzing the Supreme Court verdict. Also, we'll be discussing Nigeria's global ranking on the corruption index. The federal government has described the present ranking as baseless, with the EFCC saying same. However, SERAP is saying they are not surprised with this judgment. What's your take? What would your take be after we discuss it? Well, that is up to you. It is now time to welcome our guest, who together will be taking a look at these issues. It's nice to have you here, Barrister Adamu Ibrahim.
My pleasure. Good afternoon.
Good afternoon and welcome. Barrister Steve Adaramoye, it's nice to have you.
Thank you very much for having me.
And Barrister...
Nice team audience.
All right, thank you very much. Happy New Year too. I think this is the first time you're appearing in the year 2020. Barrister Kingsley Chime, it's nice to have you.
I'm always glad to be here. Thank you.
All right, thank you. Well, like I said in my introduction, this particular victory, which many described as contentious, is still one that is still reverberating in the minds of Nigerians. Many did not see this judgment coming, with the sacked governor Emeka Ihedioha in several interviews saying he's still shocked. He did not see it coming. Now, in a 45-page document, the Supreme Court on Friday did give us the details, what went on in the Supreme Court that made them give that particular judgment. I'll start with you, Barrister Kingsley. With that judgment, with the details of that judgment, what is your take?
Yes, thank you so much. Let me begin. Permit me to begin by reiterating my position that I, quite frankly, believe that the Supreme Court is the final court in the land, and whatever decision they come up with remains the finality, except one appeals to God Almighty. Be that as it may, I have personal reservations to the judgment. When that judgment was delivered, a lot of restraints were put in place in order not to prejudice the reasoning behind the judgment of the court. But since the outcome, the reason behind the judgment is out, I think my position has not really changed. Because if you look at the rationale behind the decision of the court, one would readily believe that it was purely on the basis of excluded votes of 388 polling units in Imo State, which the Supreme Court said that the INEC was wrong to have excluded those results. But my position is this. Before that decision on the 20th of December 2019, the Supreme Court had earlier gave a judgment involving Nwosu, that is the APC candidate of that election, and declared that Nwosu couldn't have contested under the APC as a double candidate, having represented the APC and AAN. Given that as it may, one would reasonably expect that with that determination of the Supreme Court, that would have been the end of that petition, as it were, because what the Supreme Court has done, in effect, is to say that Nwosu was a candidate of the APC in the same March general election, governorship election. And if that is the case, Uzodinma couldn't have been a candidate of the APC in the same election. So this is where the issue was. It is, before we go into the details of the facts or issues raised by parties in that decision, I think the determination of that decision would have, of course, given an insight of what to expect. If you look at the Electoral Act and the Constitution, there was no condition for independent candidacy. Yes, Nwosu was said to have represented APC in that election, and there was no way. In fact, I read the reasoning of the Supreme Court. They said that the PDP and of course the what is his name, the PDP candidate, they couldn't have raised a fresh issue on appeal for the first time, Supreme Court for the first time, without the leave of the court. And I totally disagree with the Honorable Court, with due respect. If you look at the decision of the Supreme Court in Tazo against current governor of Benue State, or Tom, the Supreme Court has said that the only person that can challenge the nomination of a candidate for an election is a participant in that nomination or primary election. There was no way what is his name, Meki Hedio, could have challenged the nomination of Uzodinma without being a member of APC. He wasn't a member, so he lacked the local standee to challenge the nomination of Uzodinma as it were, based on the Supreme Court decision. So the Supreme Court cannot, blow hot and cold by saying that not being a member of a political party or not having contested or nominated by a political party, you cannot challenge it. How then do you come up with you ought to have raised it at the not even election tribunal, but at the either state or federal high court, as it were? So my position is that the Supreme Court has erred with greatest respect that with that decision, that would have been the end to that governorship election petition tribunal without more.
All right, thank you. Barrister Darmoye.
I think I disagree with my friend.
All right.
Learned friend. The issue that was raised, as per the issue that was raised, ought to have been raised with the leave of appeal court. All things being equal, the original jurisdiction of the party to raise that issue is the federal high court. I mean, either the trial court, the tribunal. So if they want to raise a fresh issue, all things being equal, they ought to have raised it with the leave of court. Have not done that. It erases the potency of that case, as it were.
All right.
Now, when you look at this very case, it is a case, more or less, there are certain recurring anomalies in our electoral system. The issue, even the second issue that we are going to treat, where we are today, if you look at it very well, you will discover that electoral fraud is so manifestly present, rampant in our electoral system. At the collation stage, the ward, the local government, and the state level, as per governorship election, anything could happen. And if you look at this judgment critically, you will discover one of the things the judgment is trying to address is the issue of bribing, of corruption in terms of electoral collation. At various stages, electoral result could be tampered with. You understand? And I think when I read the judgment, I think kudos ordinarily should be given even to the Supreme Court panel when you look at it. And if I may just say, the appellant said inter alia that election was held in 27 local government, 305 electoral ward, and 3,523 polling units. The third, it alleged that the third respondent shortchanged, excluded, that was the word used, excluded its vote, their votes. That is the vote of Senator Hope Uzodinma and All Progressive Congress. They said the third respondent, that is INEC, shortchanged them by not excluded their result from 308 polling units. That is their case. And having said so, they put their cases together and call evidence to it. And the other party, rather, before even reaching the level of evidence, the other party, rather, transverse, that is, they oppose, in their response, they oppose the averment of Senator Usodima to the fact that, look, the result where you said you claim was forged, and at the same time was forged, and by the time they were deliberating, considering the issues, the guy, the respondent, Senator Hope Usodioma and All Progressive Congress, tabled their result. How their result was excluded. They said it, and they call evidence to support that very position.
All right.
Now, having supported that position, which is what the law requires of them, as stated in Buhari and Obasanjo, that if somebody is saying that there was electoral fraud, or my result was excluded at the local level, or at the state, or at the ward level, or at the local level, or at the state level, it is incumbent of that very person to prove that such was done. And those people that traverse at the same time, they must be able to give credible evidence to the fact that it was not so. By the time the by the time also the applicants, the appellants rather, by the time they were proving their case, they call witnesses, 54 witnesses, to the fact that, look, at this very they produced the result, and they produced the result. The result that was produced was the duplicate of the original, and they call a witness, a police officer. You know, it's normal thing at the center when an election is counted, is recorded in a form that is EC8 form, and that form will be given to the security officer, to the party agent, and all those people.
So in essence, you're saying the APC was able to prove
exactly.
Yes.
I'm trying just to go into the nitty-gritty of the matter.
Okay.
On the other hand, in traversing the averment of the appellant,
okay,
the respondent, all of them said that it was not true, okay, and they allege forgery, which is a criminal matter. All things being equal, having alleged forgery, they have to prove it beyond all reasonable doubt, whatsoever and howsoever. But unfortunately, they couldn't do it. The first respondent, Honorable Rebecca Ihedioha, called 4 witnesses. The People's Democratic Party called some witnesses too, but the 3rd respondent, INEC, could not call a single evidence. You understand?
Right.
And that, when you look at that, it's very, very grievous.
Right.
It's a very serious point.
Thank
so
you.
At the end of the day, at the end of the day, when they look at it, it was the contention at the lower court. Don't forget that at the lower court, at the appeal court, there was a dissenting judgment.
Yes, I recall. We'll still come to that, Barrister Adami. Let's quickly give Barrister Adami the floor. Go ahead. What's your take?
Okay, I must say the judgment in the case between Emeka Ihedioha and Senator Hope Uzodinma as decided by the Supreme Court, which my learned friends have talked about, is the final court of the land, and no doubt about it. You see, when you look at that judgment, you must give kudos to the Supreme Court.
All right.
That is judgment in accordance with the provisions of the law. You can't fault that judgment as far as the laws are concerned. Because before the Supreme Court came into the decision in that matter, it made references to its earlier decisions. It's not as if this particular case is laying a precedence for the very first time. No. It made references to previous decisions of the same court. Look, we must let's even get to understand what actually happened in that particular matter. The nitty-gritty is that Senator Hope Uzodinma is saying that elections held, no doubt about it. INEC said elections held, no doubt about it, because they conducted that election.
Of course.
PDP agreed that yes, elections held in the entirety of the constituencies in Imo State, no doubt about that. All the parties had consensus at EDM with respect to the holding of elections in the entirety of these constituencies in Imo State. Good. Now let's move to the next step. Elections were held, no problem. What happened? Senator Hope Uzodinma is saying that, look, at the collation stage, 388 polling units were excluded from the final result that was released by INEC. That was his contention. Don't forget that all of them agreed the elections were held. When Senator Hope Uzodinma now said 388 polling units were excluded from my own result, it was not collated, it was not added. That if these results were added to my own result, certainly I'll be the winner. So on that basis, he went to court. He has alleged, he has brought witnesses, he has proven his case. But at the tribunal, judgment was given against him. He went to the Court of Appeal. At the Court of Appeal, he canvassed this same argument. That look, 388 polling units were excluded. INEC and Emeka Hioda on their own side said, look, yes, we agree, elections held. These results were there. But that these results were fake results. That was what they alleged, that the results were fake. Now, in election jurisprudence, once an averment has been made, and you from the other side, in countering that averment, you're not saying that the result is fake. You are duty bound
to prove. It is fake.
How that result became fake. And in proving, you must produce two results. The fake one and the original one. So the burden has shifted from Senator Hope Uzodinma's table to the table of INEC and PDP to now prove how fake is the result which Senator Hope Uzodinma is contending that were excluded where. INEC didn't do this. The PDP didn't do this. At the Court of Appeal, it was a judgment in favor of Emeka Hioda, but there was a dissenting judgment. They didn't get tired. They moved on to the Supreme Court. In getting to the Supreme Court, the same argument was canvassed. And don't forget that Emeka Hioda raised a preliminary objection to the hearing of that appeal at the Supreme Court on the grounds that Hope Uzodinma was never a candidate of the APC. The Supreme Court said it was a preliminary objection which was raised. The Supreme Court immediately dismissed that application on two grounds. One, that it was a pre-election matter which has long been settled. And what we are dealing with here is an election matter. Pre-election matters are not tribunal matters. It has been settled long before now. So, and second issue, which the Supreme Court used in dismissing that preliminary objection, is that, look, at this point, even if you are raising this issue as a fresh issue for the very first time before us, you need to seek the leave of this honorable court before you can raise such issues. That leave was never sought. And the practice of the trial courts is clearly different from the practice of the appellate courts. If you are conversant with the practice of the appellate court, you discover that mere refusal to seek leave can deny you completely of the entirety of your case. And that's all. So, all in all, if you look at that judgment, you must give kudos to the Supreme Court, and you must say it's judgment according to law. And that's my position.
Can I quickly just react to what the last speaker said? You know, there is a misconception here. Why I didn't go into the merit of the case is because jurisdiction is the life wire of every case. Once the issue of jurisdiction is determined, that of course affects the life of the case. My position, I don't want to join issues with whether or not the 388 polling units were collected or wrongfully excluded and all of that. My position is that since the Supreme Court has taken a position with respect to Emeka Hioda, sorry, Emeka Hioda, no, Uche being a candidate of APC and APP, there couldn't have been any other representative of APC in the same election. The issue of leave, we all know there's exceptions to leave to raise fresh issues on appeal for the first time. One of those exceptions is the issue of jurisdiction. And this election, this decision was handed down on 20th of December 2019, while the Supreme Court decision was handed down on 14th of January 2020. So there couldn't have been time within which the People's Democratic Party, that is PDP, could have raised, could have applied or sought and obtained leave before raising such fresh issues. And of course, the Supreme Court has the jurisdiction to take judicial notice of their own decision. I read the introductory part of the judge. I read the judgment, both hook, line, and sinker. And I will tell you, I took every word for word and letter to that decision. And the way the Supreme Court, disregarded that motion being filed by PDP to challenge the propriety of that petition, having held that Nwosu was a APC candidate. One of the grounds, exceptions under which you can raise fresh issues on appeal is jurisdiction, like I said. And it is upon, immediately that decision was handed down, that the PDP could have raised that issue, which they did timelessly. Secondly, the issue of fair hearing, and the last of it is time constraint. And I've emphasized there was no time within which to raise this issue. So, Supreme Court couldn't have said that Nwosu was a candidate of APC, and what do you call him? Also a candidate of APC. It couldn't have been so. So I believe that the Supreme Court erred with greater respect to the justices of the Supreme Court, and I hope that in future Supreme Court will have opportunity to retract or to try to correct this anomaly. Yes, as it is, I agree totally that remains the law. And no amount of protest or criticism can change the position of the Supreme Court, except until when opportunity presents itself in future. So I still maintain that Supreme Court erred. You cannot go into the merit of the case without determining the jurisdictional issue, which PDP has raised timelessly.
I think.
All right.
I disagree with my learned friend. You see, the issue of jurisdiction, as you have mentioned, is pivotal to any case before any court. The court indeed address it exhaustively by saying that leave, even I told you I'm going to raise it at all, leave of the court or to be sought for before you can raise it. And having failed to raise it, it is very, very it's a serious matter. They have solved it by saying that it is a pre-election matter and ought not to be raised at that very level. Because don't forget that when we are talking about the issue of fair hearing, the moment a matter is not, an issue is not competent before the court, and one of the things actually that makes it incompetent is that very particular issue of leave, having failed to obtain the leave of court, it makes that application incompetent.
I'm sorry for having a second bite at the chair. Just a moment. Permit me to read a ratio of the Supreme Court decision handed down by immediate past CJN, Chief Justice of the Federation, in Tazo and Arezo, that's your term. The Supreme Court said, and that position remains the same as it is today, that it has been held in a plethora of cases that nomination of candidate or political party for an election in an inter-party affairs of the political parties over which the court have no jurisdiction. Also settled is the principle that the only way the court can get involved in matters of nomination of candidate for political party is as provided under section 87, 8, 9, or 10, depending on which of the version of the Electoral Act you are using as amended. One is used, yes. And it's only a candidate who participated in the primary election or contest in the process leading to the emergence of a candidate of a party to an election has the locus standi to invoke the jurisdiction so conferred on the court to challenge the said nomination. It is not every or any member of the political party concerned that has the locus to do so. The position of the person who is not a member of the political party concerned is the same. In fact, is a busybody.
What the Supreme Court is saying that even Emeka Ihedioha, what the Supreme Court is saying in effect is that even Emeka Ihedioha couldn't have, even with leave, made the such application because he's not a member of APC. He never participated in the nomination or primary election of the APC. So it is a jurisdictional matter. Immediately the Supreme Court handed out that decision on 20th of December 2019. It becomes a jurisdictional issue. Be that as it may, ordinarily, Emeka Ihedioha ought not to have raised or doesn't have the locus standi to raise that jurisdictional issue. That is the question. The Supreme Court didn't really address that issue properly. That is where my bruise lies. And if the court has taken cognizance of its earlier decision, which it has the duty to take judicial notice of its decision, it would have qualified Uzodimma from that petition, and that would have been the end of that petition. That is my position.
Okay.
I disagree to the extent that the person you are alleging participated in the election. No doubt about that very fact. You understand? And to say that he didn't participate is misconception of the whole issue. You understand? Okay. So the issue of a judicial advisory level, you know, being raised, you can raise it at any time, but it has to be anchored on the proper position of the law. The law is saying that that application is invalid, is incompetent, in so much that it does not comply with the position of the law as to seeking the leave of court, because the matter you are even challenging is a pre-election matter. And when you read that very particular, that is even the position of the law and Supreme Court authority to defend that, if you are raising the matter of such nature, it ought to have been raised at the court below. You understand? Most especially at the tribunal. So a lot of things being equal, at the level at which it was raised, it was strong. So the Supreme Court rightly held that Hope Uzodimma was the right candidate of APC.
All right, we could go on and on and on. This is law. But let's examine the gale of defection. Let's go into the politics. You know, we've seen mass protests by members of the PDP in different states of the Federation. As the program was on last week Sunday, there was a mass protest in Imo, in Anambra. Also, we had a protest in Lagos as well, and many states of the Federation. And barely 2 weeks after the Supreme Court handed the victory to Senator Hope Uzodimma, we've seen a gale of defection. You know, the Deputy Speaker of the House has defected from his party to the ruling All Progressives Party, as well as 9 other members. What do you make of this?
Well, you know, talking about politics in Nigeria is one of the most difficult things to talk about. Most of the politicians we have in Nigeria do politics not because they have ideologies which they stick to. Most of them go into politics because of what they can make for themselves. That is for their personal enrichment or personal aggrandizement. So they are not committed to the party under which platform they contested an election. And funny enough, when they go misbehave, or once what they want is not exactly what they got, they come back and tell the electorate, incite them to go on demonstrations, and then the electorates who cannot even decipher the wrong from right will just take on the streets without a second thought. If you look at the way some of our politicians play politics in this country, you will discover that there's no reason to die for any politician. Look, it is shameful that some of the House of Assembly members in Imo State who were elected under the platform of a different political party and won election go into the House just because the baton has changed hands, just because the governor, that's
Senator Hope
Uzodimma is now the governor of Imo State. You felt uncomfortable that perhaps you'll be losing your seat as a PDP member or as a Speaker of the House or Deputy Speaker of the House. You felt perhaps the man will come and before you know it, you are losing your seat and you know you're not prepared to lose your seat. So the best thing is, let me just even defect to that political party, and I will continue to eat the goodies there. I mean, it's unfortunate that things like this happen. It has happened even in the Senate. It has happened in the House of Representatives. It's not the first time. So most of our politicians don't play politics because of an ideology. They are not going there to protect the interests of the people. Rather, they are going there to protect their own personal interests. And if you are there to protect your own personal interests, certainly you always want to do everything that will favor you. That's the kind of things you see.
Well, why this is so surprising to many Nigerians is because in Imo State, there is no member of the APC in that particular House of Assembly.
Certainly, not even one.
Ironically, the PDP are among those, PDP members are among those who dumped the party for the ruling All Progressives Congress. Yeah. And many are saying this is taking political opportunism to a new level. You know, what will make it different? What will be different if a governor is of a particular political party and we have a mix of other political parties in the House of Assembly, you know, without necessarily the party of the ruling or of the governor rather, in the House? Would it make any difference, Barrister Chime?
Well, if you, you know, like my learned friend said, the defection of State House of Assembly members to APC is not unexpected. You know.
Oh, you saw it coming?
Well, of course, and more. In the coming days, more are still going to join the APC.
Wow.
You know, the essence is this. You know, like I said earlier, if Hope Uzodinma truly won those 388 polling units he claimed to have won, upon which the Supreme Court brought him in, how come there was no single member of the House of Assembly that won that election? It is a mystery. So the issue of people moving from one party platform to the other is not new to us. It has always been with us. And it is about political interest. People want to, you know, be in a place where their own interests will be first and foremost protected. So I even envisage more people joining the APC in the coming days. So it's not unexpected. So what they have done, in fact, is that because there were fears that since the Supreme Court has declared Hope Uzodinma the governor of Imo State, and there was no single member of the State Assembly that it is dangerous, that there were fears that he could be impeached any moment. So the issue of you know, people trying to lobby is the issue of lobbying, and if you feel that your interest, I mean, as a person, as a member of State House of Assembly, is more protected in a particular party, you can join. That is one of the loopholes in our laws where people can defect from one political party to the other. If it were to be that once you defect, you lose your position upon which you contested, it would have been different. But what we're expecting is not un-Nigerian. It is expected. And I hope that in the coming days, because the Supreme Court decision on Uzodinma has come to stay.
Yeah.
What we are doing here is post-mortem analysis.
Of course.
So in the next 3 to 4 years, Uzodinma is going to be the governor of Imo State. So the campaign has no, for me, it has no relevance. It's more of a personal opportunity for them to get whatever they could within the platform. So that is my position.
All right, Barrister Damari, what's the implication of this? I mean, the gale of defection to constitutional governance and democratic representation in Nigeria.
This shows us that politics is yet to mature to the level of where people are fixed to principle and ideology. Most unfortunately, if you see politics in Nigeria, people play politics. Majorly, people play politics for the interest of their pocket, for the interest of their family. Even hierarchical down, when you look at it at every stage, the interest, when you see some people jumping to the street, telling you that they are protesting this way or the other, it is not because of the interest of the people. It is not because of the interest of the state. It is not because of the interest of the nation. It is because of the interest of those that are involved, those individuals. What can we get out of this system? You know, if another person should occupy that seat, that gale of defection will immediately follow. Actually, it has undoubtedly, it has effect. You know, if the man is there and there is no representative from his party, you know, he could easily be impeached. But I can tell you, in Nigeria of today, with lobby, with money, you know, many are still coming to that very part, but to that very to APC. You know, many are still coming there, and at the end of the day, it is politics. I mean, it is the nation, the people that is going to suffer, because there is no altruistic purpose for which the defectors are moving to that place. The politics ordinarily is supposed to be government of the people, for the people, by the people. But unfortunately, the people that are there, they are there for their own interest, not for the interest of the people. The ultimate interest is the interest of the people. At any material time, that particular interest is jettisoned. If you see anybody talking to Buhari now, people that are eating from Buhari's table, one way or the other, will try, even without Buhari content, to maltreat that very person, even what Buhari does not send them. So when you are looking at it, as of today, the most lucrative industry in Nigeria today is politics. So on the stretch of that very one, people are there to consolidate their own estate, their own interest, and no more, no less.